Every eviction process is different and dependent on the information in the lease or rental agreement signed by the tenant and the landlord. It is always best to exercise meticulous file keeping to avoid errors that could be exploited by the tenant, especially the history of rent payments. Filing an eviction action takes time and patience. Going to court may be a long and tedious experience for a landlord who handles multiple properties. Most landlords are advised to try to work things out with the tenant outside court. It's only in extreme cases when a landlord resorts to file for an official eviction action. In this video, we'll go over some helpful details and helpful tips for landlords to refer to when evicting a tenant to ensure the process goes as smoothly as possible. Also, we want to point out that a landlord can also ask for legal advice from an attorney for more information on the eviction rules. The best legal advice will come from an attorney who is well versed in Minnesota law. So with that being said, let's get started. First up, we will go over some common eviction reasons. The first step all evictions must take is providing a notice called a notice to quit. There are only some states which do not require a notice to quit, and even then, it depends on the reason for eviction. The notice serves to notify the tenant that they are in danger of eviction by providing the reason for eviction and how long a tenant has to pay, comply, or leave before the process begins. A landlord cannot evict any tenants without this notice. In the state of Minnesota, there are 4 main reasons for a tenant to be evicted: failure to pay rent or non-payment of rent, violation of the lease or rental agreement, conducting illegal activity, and non-renewal of the lease after the end of the rental period. Let's dive into these a little bit further. Failure to pay rent or non-payment of rent. A landlord can evict a tenant for failing to pay the rent on time. Before a landlord can start with the eviction action for failure to pay past due rent, the landlord must give the tenant a written 14 days notice to quit. This means a tenant must move out of the property in 14 days to avoid eviction. If tenants who are being evicted for not paying rent on time manage to pay all past due rent in full to the landlord before the 14 days are up, the entire eviction process stops and they continue staying within the rental premises. A landlord can file for an eviction action for tenants who do not vacate or leave the rental premises by the end of their notice period. This only applies to at-will tenants or tenants who have not signed a written lease or rental agreement or contract with the landlord. Landlords are not required to give a written notice to tenants who are on a fixed-term lease or are not tenants at will. They may proceed to file an eviction against the tenant immediately for not paying rent on time. Violation of the lease or rental agreement. A lease agreement can vary from tenant to tenant. It contains the responsibilities of each party during the entire duration of the tenant's stay. A tenant may face eviction for violating the terms of a lease. Landlords and tenants are required to uphold the terms of the lease agreement at all times. The landlord may allow the tenant time to cure the violation, but are not required by Minnesota law to do so. There is no specific notice period for this type of eviction because it will depend on what was indicated in the lease. Lease violations in Minnesota eviction include damage to the rental unit, smoking in non-smoking areas, failing to comply with housing codes, too many people are living inside the rental unit, housing a pet in a pet-free rental unit or rental premises. The landlord may continue with an eviction if the tenant remains inside the rental unit after given the notice period. Conducting illegal activity. In the state of Minnesota, landlords and tenants have to refer to their written lease agreement to handle cases involving illegal activity. Minnesota law does not specify a required notice for this category. If a tenant has engaged in illegal activity on the rental premises, the landlord must follow the regulations stipulated in the lease. Examples of illegal activity include, but are not limited to, theft, violence, assault, human trafficking or prostitution, possession and firing of an illegal firearm, involvement in the creation, distribution, or consumption of a controlled substance. In minor cases involving illegal activity, the landlord may offer the tenant the chance to cure the violation, but they do so at their own risk, so they're not required to do so. Should the tenant remain on the rental premises after their notice period ends, the landlord may continue with the eviction process. Non-renewal of lease at the end of the rental period. A Minnesota eviction process does not allow a landlord to evict a tenant without a good case. As long as the tenant does not violate any rules, they can stay until their rental period ends. However, if the tenant becomes a holdover tenant, the eviction process may begin after the appropriate notice period. A holdover tenant is someone who overstays their lease term without applying for renewal. A landlord can evict a tenant who stays in the property even a day after their written lease ends. This type of notice or eviction usually only applies if the landlord wants to end the tenant's lease. Should the tenant remain in the rental premises even after their notice period ends, the landlord may continue to file an eviction action in order to evict the tenant from the property. Filing a complaint. The next step in the state of Minnesota eviction process is filing a legal complaint in the correct justice court. Costs for filing may be pricey, so be ready to pay for the cost. A landlord must file a complaint only after the notice period has passed. Successful evictions rely on correct filings, so the landlord must file all the forms correctly. Steps in filing an eviction action. Proceed to the justice court the rental property belongs to. Fill out the forms. Pay the filing cost. Timeline. It takes 24 hours to 30 days, depending on the reason for eviction, before a landlord can file a complaint. The 24 hours notice period can fall under the categories wherein both parties must renew their written lease agreement. Notice to comply. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. Serving the tenant. The next step in an eviction process is serving the summons and complaint to the tenant. The landlord must not serve the documents by themselves. The summons and its supporting documents must contain information, such as the date and time of the court trial. Minnesota allows individuals who are uninvolved in the case to serve these documents. They must be delivered within 24 hours from when the court issued the summons for evictions related to illegal activity. How to serve documents to a tenant. The summons and its corresponding documents must be served through one of the following methods. Professional service. The summons and complaint is served to the tenant in person. Substituted service. If the tenant is unavailable and personal service cannot be conducted, a copy of the summons and complaint may be left at the tenant's place of residence or rental unit with someone who lives with them. After serving the summons and complaint. In the state of Minnesota, tenants do not need to file an answer with the court for a trial to be scheduled. The tenant must attend the hearing if they wish to provide their own defense. Once the summons and complaint have been served on the tenant, they can request a continuance that lasts no longer than 6 months and no earlier than 6 days, but only if they can prove that they need the time to bring forward an important witness to testify. The landlord may also request for a continuance that lasts no longer than 6 days. Timeline. The summons and complaint must be served 24 hours to 7 days after the court issues it, depending on the reason for eviction. A continuance may be filed by either party that lasts 6 days to 6 months. Asking for possession. Filing a motion to obtain judgment and getting a judgment for possession. To win and accomplish this step, landlords must provide a strong argument backed up by solid evidence against their tenants. Should the tenants fail to show up to the hearing, the landlord may win by default. Either party may appeal the judgment within 15 days from the time judgment for possession was issued by the court. Next procedure, if the tenant disagreed to file an answer, filing an answer is not necessary for an eviction hearing to be held or scheduled. The court trial must continue and come to order. Should the tenant be unable to attend the hearing, the judge may issue a default judgment in favor of the landlord. This means the tenant must move out of the rental property. However, if both parties are present, the landlord must support their claim with evidence and show it to the judge. This includes, but is not limited to, the following: copy of the deed and the lease/rental agreement, rent receipts, rent ledgers, bank statements, witness statements, photo and video documentation of the violations committed by the tenant. Either landlord or tenant can ask for a court hearing held in front of a jury, but doing so will add more time to the eviction process and possibly move the date of the court hearing. Alternatively, either party must also enlist the service of an attorney to assist them in court to handle this case altogether. Timeline. A hearing for an eviction action is scheduled depending on the reason for eviction. If the eviction action was related to illegal activity, then it's held 5 to 7 days from the issuance of a summons from the court. Any other type of eviction action requires 7 to 14 days from the day the court issues a summons. An appeal adds 15 days to the entire process. Getting possession. After the landlord wins the case and gets a writ of recovery. Once the landlord wins the case, and provided the tenant does not file for an appeal or reconsideration, the court will issue a writ of recovery immediately after the court rules in the landlord's favor. The writ of recovery is a court order that informs the tenant that the tenant must move out of their housing on the property, or else they will be forcibly evicted. If the tenant fails to do so, they will be forcibly evicted. Move out process. The final step in the eviction process is to move the tenant out of their housing on the property. Minnesota law dictates that tenants have a maximum of 24 hours to vacate the property once the writ of recovery is posted or delivered to their unit. Sometimes a tenant can leave behind personal property after a forced eviction. The tenant's personal property has to be stored by the landlord for at least 28 days. Should a landlord choose to dispose of the tenant's personal property, then they must once again inform the tenant of their plan 14 days before selling. Timeline. A tenant has 24 hours to 7 days to leave the rental premises from the moment the writ of recovery is delivered to them. This depends on whether the tenant received a stay of execution. So it takes an average of 2 weeks to 3 months to complete the eviction process. Showing evidence. How to keep good records. If the tenant disagrees with the eviction request and they reply to the court, it's important that you keep extremely good records of everything so that you can provide proof to the judge and win your case. This part can make or break your entire eviction request in the event of a dispute. You can stay organized by keeping a physical paper trail, scanning documents, backups, and property management software. Evidence to show for not paying rent. If the tenant doesn't pay rent and they dispute that claim, it's important that you show the judge the following: your lease agreement, all payments, all payment returns, and all messages. Evidence to show for lease violations if you are evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damage, or any of these methods are useful in providing the violation. Security cameras, video of damages, pictures, and lease terms. And that's a wrap for today's video on the Minnesota eviction process. We hope you found this video helpful and informative. If you want to dive deeper into the process in Minnesota, we've got you covered. In the description below, you'll find a link to a detailed blog post that goes into great detail about the eviction process in Minnesota. Thank you so much for watching today's video, and we'll see you in the next one.